Hello everyone, I am Advocate Akhil Solanki, Associate at LEXIS and Company. So today we're going to discuss an observation of High Court in which the Madhya Pradesh High Court Indore bench recently stated that the term ordinarily resides under Section 9 of the Guardians and Wards Act has to be determined based on the intent of the person concerned residing at a particular place upon reaching there. So in this section 9 of the Guardians and Wards Act, it deals with the jurisdiction of the court with respect to certain applications. The bench comprising Justice Subodh Abhyankar further observed that the term ordinarily resides has nothing to do with the time spent at a particular place. Facts of the case were that the petitioner and the respondent were married and were living in Nagda. Due to matrimonial discord, the petitioner left and took her daughter with her to Nagpur. So, as to get to the custody of his daughter, the petitioner moved the lower court under Section 7, 10, and 12 of the Act. In response to the same, the petitioner moved an application under Section 9 of the Act, contending that the said trial court did not have jurisdiction to entertain the application moved by the respondent. Since the minor child was residing in Nagpur, however, after considering the decision of the apex court in Ruchi Maju versus Sanjeev Maju, the trial court rejected the application that after examining the submission of the parties and document on records, the court held that it is apparent that the word ordinarily resides has nothing to do with the time spent by a person at a particular place, but his intention to reside at a place after reaching there is to be seen. So, in the case at hand, the daughter was residing with her father. She took off with her mother to Nagpur. In Nagpur, her mother got her admitted in school. In Nagda, it clearly leads to one and the only conclusion that after reaching Nagpur, the minor intended to reside at Nagpur only. In such circumstances, taking note of the decision rendered by the Supreme Court in the said case of Ruchi Mazu Supra, this court is of the considered opinion that the minor intended to reside at Nagpur only, which also gives rise to the presumption that she is the ordinary residing at Nagpur only and not at Nagda, where her father has filed the application. So, with aforesaid observation by the court set aside the impugned order passed by the trial court, and the application moved by the petitioner under Section 9 was allowed. So, thank you guys. I hope you have learned something from this observation. I will see you in next video with some other information. Thank you.